Okay, it looks like the clock has clicked over into noon, so I will say good afternoon to everyone. We're gathering as a law school community today to discuss the killing of Breonna Taylor. It's a sad occurrence that we keep having these sessions. Most recently, at least on this theme, we had the benefit of learning from our faculty with regard to the murder of George Floyd. I want to start by thanking Professor Coleman, Associate Dean Brooke Coleman, Associate Dean Charlotte Garden, who took the initiative to put this program together. Really appreciate their quick work. The same to Claudine Ben-Mar, Stephanie Tortorelli, Colin Watrin, all of the folks behind the scenes who make it possible for us to be able to gather and learn together. I wanted to start with a quote that I know was really meaningful for many of us when we had the pleasure of having a presentation from Professor Terry McMurtry Chubb last week. And as she acknowledged the killing of Breonna Taylor, she used the theme, when having a heart for justice is not enough. And I really think that that's the right entree into our program today. So what do we do as legal professionals, as aspiring lawyers, with our frustration, our anger, our fear, our disbelief that we're back here again talking about the killing of a Black or brown brother or sister? Fortunately, we have amazing faculty who are going to help us today to sort through some really confusing and murky facts, to understand the process with regard to indictments. And so I want to express my great appreciation to our two faculty speakers today, Professor Deborah Ahrens and Professor Mike Russo. I'm going to keep the introductions really short because I know you want to hear from them. Professor Deborah Ahrens is a professor of law here at Seattle University School of Law. We're so fortunate to have her. Many of you have had her as a faculty member teaching criminal law, criminal procedure, or evidence. She came to us with a public defender background from work that she did in South Carolina, and her scholarship really focuses on the cultural significance of contemporary policing practices and criminal sanctioning regimes. So she is the perfect person to help us understanding this setting that we find ourselves as a society in again. And she's going to start first with an introduction, then we're going to go to Professor Mike Russo. Professor Russo is a distinguished practitioner in residence here at the law school. Again, so fortunate to have him. He teaches criminal law, evidence, and forensics for us. He also comes from a public defense background, having spent 22 years as a deputy public defender in Los Angeles, California, including working on capital defense. And once Professor Russo is done, we'll go back to Professor Ahrens. So I'm going to turn it over to Professor Ahrens. And again, a huge debt of gratitude for the two of you for taking your time and giving us the benefit of your expertise and wisdom today. Professor Ahrens.
Okay, and thank you. That's a really good setup for what I wanted to say very briefly in introduction, which is this is a death that didn't have to happen. And Professor Russo and I are not going to be able to explain to you exactly why it did. We're not going to be able to explain to you exactly how the grand jury reached the conclusions that it did in this case, but we can hopefully have a conversation at the end of this about how we can prevent, as lawyers, as proto-lawyers, as members of the community in general, something like this from happening again. And so we're limited, right, by the information that we have available. There have been developments that have been happening even as we've been putting together this presentation fairly quickly. And so we're limited by what we know. But what we can do is try to give you the tools that you need to try to understand what happened here and how to go forward. So what we're going to do is Professor Russo is going to give you sort of a factual overview of what happened here to the extent that we've been able to divine what happened here. Then I'm going to explain a little bit about how the Fourth Amendment works, what it does and doesn't constrain the police from doing, and how it might help you understand the police's actions here. Professor Russo is then going to talk a little bit about the criminal charges that could or couldn't be available here, and how self-defense might interact with what the police were doing to execute the search warrant. Then I'm going to talk to you a little bit about how grand juries in general work and maybe how they work in Kentucky in particular. And then hopefully we can have Professor Russo and I something of an exchange about things we think could happen differently going forward, and also open it up for questions from you folks about what happened and what we can do. So Professor Russo, would you like to take it from here?
All right, and thank you. So I spent all morning and some of last night trying to read everything I could about Breonna Taylor and about what happened in this case. And I want to try to give you a factual summary, but that we're inhibited in that because the authorities in Kentucky have not been particularly forthcoming with information. And what information they've put out has been inconsistent. So I'm relying now on newspapers like the New York Times and the Washington Post, the local newspapers, and then television reports. I was watching some television video from local news stations in Kentucky starting the day that this occurred. So let me just try to cover what we know, or what I think we can be confident about. All I've read about Breonna Taylor, she just seems like such a wonderful young woman, just 26 years old. She worked as an emergency room tech in a hospital in Louisville. She had no criminal record. She wasn't a suspect in any crime. She lived at 3003 Springfield Drive, apartment 4 in Louisville. She shared that apartment with her younger sister, and very often they had her infant goddaughter there staying with them. It was only a 950 square foot apartment. It wasn't a very big place, and that's going to be important later. So on the night of March 12th of 2020, Ms. Taylor was at the apartment with her boyfriend, Kenneth Walker. And also, he was not a suspect in any crime and also had no criminal record. Ms. Taylor had terminated a relationship with a man named Jamarcus Glover about a month before this. And Glover was heavily involved in drug sales out of a set of abandoned homes that were about 10 to 12 miles away from Breonna Taylor's apartment. Louisville police officer Detective Joshua Janes swore out a search warrant affidavit on March 12, 2020. He was not involved in the search that occurred later, even though he was the one that swore out the affidavit. The judge, Judge Shaw, I believe her name was, signed that search warrant at 12:37 p.m., so in the early afternoon on March 12th. You can see from the signatures on other warrants that she looked at that warrant for about 2 minutes because she signed the one before it at 12:35. The police officer sought a no-knock warrant. In other words, that they didn't have to knock on the door and they could simply break it down if they wanted. And that was authorized by the judge. There is nothing apparently in Kentucky that requires them to get pre-authorization for nighttime service. Where I used to work, they would have had to do that. I don't know why the police waited 12 hours to serve the search warrant, but they didn't do it immediately, even though they had it that afternoon. Neither Breonna Taylor or her boyfriend, as I said before, were themselves suspects in any crimes that Janes was investigating. The focus was on Jamarcus Glover and the 4 residents that he was apparently selling drugs out of that are about 10 to 12 miles away. The warrant affidavit says only a little bit about Breonna Taylor and her apartment. Most of Jane's affidavit concerns Glover and the 4 other residences. So in looking at the warrant, which I've had since yesterday, I found 5 things that refer in any way really to Breonna Taylor. Number 1, that Glover, her former boyfriend, who was known to be involved in drug sales, had frequently visited Breonna Taylor's apartment, but there's no times listed as to when that occurred. They had been boyfriend and girlfriend for 4 years. The second thing was on January 16th, so about 2 months before the search warrant was served, Glover went to Breonna Taylor's apartment at 3003 Springfield Drive and picked up a small package labeled as a U.S. Postal Service package. No further description, nothing about that package being otherwise suspicious. Third thing in the affidavit was Glover had received mail at that address before, but no times were listed when he received that mail. Fourth was Breonna Taylor's car, and Breonna Taylor herself had been seen at residences associated with Glover on different occasions, but that was what they said, quote, different occasions, no times again listed. And then fifth, Glover listed Breonna Taylor's address as his to receive mail on February 20th of 2020. But nothing more about that. That's it. That's all that was in the warrant as to Breonna Taylor in her place. So on March 12th, 2020, at midnight, Louisville police officers in plainclothes were surveilling Breonna Taylor's apartment in readiness to execute the warrant. They thought, according to their own statements, that she was alone inside of the apartment and that she was the only person there, despite the fact that she had come home a few hours earlier with her boyfriend, Kenneth Walker. The police said they could see blue light coming from a television through the window, so they knew or suspected somebody was home, and they thought it was just her. They knew that Glover wasn't there because they had arrested him 10 miles away at another place, and they had just done it that night. So they knew he wasn't there. And a little bit after 12:35 a.m., Sergeant John Mattingly, Detective Miles Cosgrove, and Detective Brett Hankinson and others approached Miss Taylor's front door. Though they had a no-knock warrant, they did in fact knock. Kenneth Walker said they did knock, or that there was a knock at the door. In fact, they probably knocked about 2 or 3 times. It's unclear whether they announced themselves as police. The New York Times interviewed 12 residents of Breonna Taylor's apartment building. 11 said they never heard anyone announce police. 1 said that he heard someone say police once. But that person was inconsistent on that point. In interviews with CNN, he twice told CNN he had never heard anyone yell police. Kenneth Walker said he never heard anyone yell police. All he heard was beating on the door. So the police said they knocked 2 or 3 times, and then they used the battering ram to knock down the door and blow through it. Walker, thinking that someone was breaking into the apartment to injure or kill him and Miss Taylor, he actually suspected it might have been Glover, fired a single shot. He said he fired that shot into the ground. He had a 9mm pistol. So he fired 1 shot, he said, either into the ground or not. It hit Sergeant Mattingly in the thigh. Could have been a ricochet if he fired in the ground, but in any event, hit him in the thigh. In response, now it's important to note, all of the Louisville police officers, I looked at their standard operating procedures. They had 40 caliber Glock semi-automatic handguns. So in response, Mattingly fired 6 shots into the apartment, and then he was dragged back by other officers. He was bleeding from the leg, and the shot that hit him had nicked his femoral artery, so he was in serious condition. Cosgrove fired 16 rounds, and what you need to know about that is their service pistol, the Glock, has a magazine that contains 15 rounds, and then it's very typical for police officers to keep a round in the chamber, so they have a total of 16 rounds they could fire. He fired 16, so in other words, he emptied the gun. Officer Hankinson, or Detective Hankinson, who was at another side of the apartment, he wasn't at the door, he was on a little patio against the sliding glass door. According to the Attorney General, Hankinson fired through the sliding glass door 10 shots. And he was firing through a window where he couldn't see what he was firing at, into the apartment. Now that's according to the Attorney General. However, Louisville police station was out there the next day filming, and they counted on the ground outside the apartment 37 expended casings, which means if you take 16 from Cosgrove, 6 from Mattingly, that leaves 15 for Hankinson. I suspect there might have been 38 out there. The news people wouldn't have been able to get into the apartment itself. If that's true, then Hankinson also would have emptied his gun, all 16 rounds he had available to them. 6 bullets struck Breonna Taylor. 1 of those tore through her heart and her lung. It would have been rapidly fatal. Within 2 minutes, maybe she would have bled out and died. The others, the Kentucky authorities just have not made clear where those shots struck her. They haven't released the autopsy report. The Kentucky State Police Lab, who initially did the analysis of the scene, said it was inconclusive which officers fired which shots. And the FBI came in behind them, and the FBI said they could conclusively determine that Cosgrove fired the shot that killed Breonna Taylor, the one that went through her heart. as far as we know, what the Attorney General of Kentucky said was the FBI was also inconclusive as to who fired the other rounds, but we just don't know about that. Kenneth Walker, Ms. Taylor's boyfriend who fired that single shot, was arrested immediately. And 15 hours later, there was a news conference called by the chief of police of Louisville. And they announced that Walker was charged with attempted murder of a police officer and assault in the first degree, both of which carry a maximum of 10 years in prison consecutively. And he was indicted by the grand jury for those 2 counts 6 days later. Last month, Kentucky Attorney General Daniel Cameron impaneled the grand jury and presented evidence to that grand jury. Grand jury proceedings are secret, so we don't know what was said in the grand jury, but we may find out based on the news today, at least some of it. The grand jury indicted only Detective Hankinson on 3 counts of first-degree wanton endangerment. We'll talk about what that means later. The prosecutor in Louisville dismissed the case against Kenneth Walker on May 26th, the attempted murder of a police officer. And they announced it the day after FBI announced they were going to conduct an investigation, but the case was dismissed without prejudice, so it could be refiled against Mr. Walker. So that's what I can say definitively. So, Professor Ahrens, where should we go from here?
Right, and even that was a lot of, I think that this is what is the right conclusion, right? I mean, this is a lot of what we're dealing with here. What I'm going to talk about for a few moments is just what the police are doing in Breonna Taylor's apartment in the first place. And so I only have one slide for you, and it just is the text of the Fourth Amendment. So if we give me a second here, I'll get it up here. In part, I'll be transparent. I don't want you guys to keep associating my face with dismal things that I am telling you. So I'd rather you have something else to look at, and you might as well look at the constitutional constraints on police. So if you take a look at this, the police, as Professor Russo told you, did get a warrant to go to Breonna Taylor's apartment. And the Fourth Amendment, and keep in mind, this is the bare constitutional minimum set of protections that states have to afford to their citizens. So as you're thinking through the things that I'm telling you, keep in mind, states could do more or less, depending on how you think about it. They could constrain police more than the Fourth Amendment does. But what the Fourth Amendment says is that we have the right to be secure in our various places and persons against unreasonable searches and seizures. And then it goes on to say, and no warrant shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seen. So you know already that the police have a warrant here. That part of the Fourth Amendment is complied with. So the question is, what about the rest of it? And the first place maybe we want to stop is that the warrant has to be supported by probable cause. There has to be enough suspicion for police to go and obtain a warrant in the first place. And the information that I need to convey to you is that probable cause is not a particularly high standard. It's well under the preponderance of the evidence standard that those of you who are law students are familiar with. So we're talking something not with a percentage fixed to it, but something well under 50% in terms of how certain the police have to be. So you're starting with a fairly low standard. It's also a standard that doesn't have a particularly precise formulation. The Supreme Court has said it's the amount of suspicion that would warrant a person of ordinary caution in the belief that evidence of a crime will be found. That doesn't necessarily mean that the person against whom a search warrant is being targeted is the person committing the crime. You can, as the police did here, get a warrant to search somebody's house, even if you don't think that they personally are involved in criminal activity. Probable cause is supposed to be the same standard in every single case, but the Supreme Court, in crafting that standard that doesn't sound all that precise, actually specifically said, we want this to be a kind of flexible standard. We understand that there's going to be geographic variation, that maybe what looks suspicious in a neighborhood in Louisville isn't something that's going to look suspicious in Woodinville here. We are going to kind of defer to police judgment about it. So this is all setting you up to understand probable cause, fairly low standard, and that our understanding of what it requires is probably going to vary contextually and geographically. That said, it still does require something. And so you can kind of think back to the set of facts that Professor Russo narrated for you that would have connected Breonna Taylor's apartment to any criminal activity or evidence that the police could have thought to find. And he gave you a lot of things to be possibly concerned about, right? The fact that none of that actually pointed to Breonna Taylor herself being involved in criminal activity, again, not just positive, but something to think about. Some of the information also post hoc turns out to have been incorrect. So one thing that was included in the affidavit supporting the search warrant, for example, was an officer who said, I checked with UPS and confirmed, in fact, that the actual target of our investigation was receiving packages at Breonna Taylor's home. It turns out that's not true. It turns out that UPS says, we were never consulted about this, and also actually that wasn't happening. And so that seems to be false information that was included in the affidavit. That's not necessarily fatal to the validity of the search warrant, but when you include false information or information that you're reckless with respect to whether or not it's false, that does cause us to be suspect of the warrant in toto. At the very least, you need to delete all the information that police shouldn't have included in the first place. And so there's maybe some reason here to be skeptical about whether or not police had probable cause, not that drug activity was occurring and that somebody was connected to it, but that Breonna Taylor's apartment was a place where one might find evidence of that. The other thing that you need to understand here, and again, Professor Russo has set you up for this nicely, is that the police showed up in the middle of the night and may or may not have announced themselves. As Professor Russo told you, usually you do have to knock and announce your presence as police officers. And there's nothing in the text of the amendment that tells you that that's so, just like there's nothing in the text of the amendment that says normally you should be executing a search warrant during the day. But the Supreme Court has said, when we look at that reasonableness requirement, when we are protected against unreasonable searches and seizures, inherent in the reasonableness of a search and seizure is that even if you do go through the process in the back half of the amendment and obtain a warrant, you have to execute it reasonably. And so for the most part, that's going to require you show up during the day, and police get a little bit more flexibility to define their day than you and I might think are civilized hours to go calling. But a bit after midnight, normally that's not a time when we execute search warrants. That's in the middle of the night. And as Professor Russo has told you, in some jurisdictions, you'd be required to get a special warrant in order to do that. In all jurisdictions, you're going to have to get a special warrant in order not to knock and announce yourself. And this case is actually kind of a classic example of why it is that the Supreme Court has read that requirement into reasonableness. Because certainly if you don't knock and announce yourself and instead you simply intrude, at the very least, you're probably, as the police did here, going to destroy the front door. The police destroyed Breonna Taylor's front door with a battering ram in order to get in. But also you're going to be intruding on people who don't know that you're the police. And that creates dangers, certainly for you as police officers, as you see here. Somebody might think that they're experiencing a home invasion. Kenneth Walker says, I heard banging on the front door. Absolutely. And I thought what that meant was somebody was trying to break into my house and harm me or harm my girlfriend. That's what I thought was going on. So risk of harm to the police officers, and of course, risk of harm to the homeowners or the home occupants when the police are responded to, perhaps with upset homeowners who are using force to repel what they think is an unauthorized invasion. Exactly the scenario here is what we worry about. And in fact, the New York Times has actually looked at the execution of no-knock warrants. And in 2017, the figures that they came up with was that these kinds of unannounced entrances by SWAT teams. So we're not even thinking about entrances by ordinary police officers like executed the search warrant in this case, but in up through 2017, at least 81 civilian deaths attributable to failure to knock and announce. Of course, here the police did have a no-knock warrant. And again, you can think about, is there enough here for them to have gotten that? The information that police submitted in their affidavit in support of the idea that they needed a warrant that permitted this kind of dynamic entry was that the boyfriend, who was not thought to be residing in the apartment, was known for running from the police and destroying things. And so they wanted that element of surprise. And in general, that drug people who are associated with the drug trade might engage in violence, might destroy evidence. Again, weak probably link here between any of those arguments and Breonna Taylor or Breonna Taylor's apartment. In any event, as Professor Russo has told you, the police say we did, even though we weren't required to, knock and announce ourselves, dispute as to whether or not that's actually what occurred. But whether or not they did, it doesn't seem like they waited a tremendous amount of time before coming into the apartment. And you can kind of see the tragic fallout from that. So that's your Fourth Amendment frame. A lot of what the police did here was procedurally consistent with the Fourth Amendment requirements, but there are reasons to be suspicious about whether or not they actually reached the standards that are set out in the amendment, the standard of probable cause or the standard of reasonableness in executing this search warrant. So from there, Professor Russo is going to talk to you a little bit about the charges that maybe the grand jury did or didn't consider in this case, and maybe the interplay of self-defense here and how that might have affected everyone's actions.
Yeah, and Professor Ahrens, I hope you'll jump in on this part too. You know, we don't know, as I said before, what was presented to the grand jury. The Attorney General of Kentucky has said that he did not think that, legally speaking, he could charge the officers with a crime, the officers who were Mattingly and Cosgrove, because they were firing in self-defense. And if he didn't think legally he could do that, I am inclined to think that he presented no evidence with regard to them and never asked the grand jury to indict them on anything. Now, we just got some more information because originally the Attorney General of Kentucky said that he presented the whole picture to the grand jury, and they decided only to indict Detective Harkinson on the charges that he's indicted on. Now, the latest thing, this was yesterday, the Attorney General said that he never asked the grand jury to return any charges against the other two officers. So I think that's more accurate, given his other statements. So the charges against Officer Hankinson were under the Kentucky statutes, first-degree wanton endangerment. You got 3 counts of that. So it would be the intended victims would be Kenneth Walker, Breonna Taylor, and Officer Mattingly. That's the only other person I can think of, or Sergeant Mattingly, who is in. So it's against those 3 as victims. You got 3 counts. First-degree wanton endangerment is in Kentucky statute says person is guilty of wanton endangerment in the first degree when, under circumstances manifesting extreme indifference to the value of human life, he wantonly engages in conduct which creates a substantial danger of death or serious physical injury to another person. First degree wanton endangerment carries a fine of $10,000 and 5 years in prison per count. So, you know, as to what could have been charged, that's tricky. Kentucky's a stand your ground state. There is no question at this point that the first person that fired a shot was Kenneth Walker at the officers breaking down the door. From all appearances, he was perfectly justified in doing that. And as a matter of fact, Kentucky law presumes that it's justifiable to use deadly force when someone is breaking into your home. And if he had no reason to believe these were police officers and he didn't hear them announce themselves, to him it looked like a home invasion. So as to the police officers then, well, if you get fired at in a stand your ground state, no matter where you happen to be, you can fire back. So the officers therefore had the right to fire in self-defense. In thinking about what more could have happened here, however, and I'm just talking now about the 2 officers that came through the front door, between them, they fired 22 shots. And your right to use deadly force exists as long as you're under a deadly threat. When the deadly threat is extinguished, your right to continue to use deadly force ends as well. In other words, they can't exact street justice and go in and shoot up people once the threat to them has extinguished. The thing about the weapons that they're using, these semi-automatics, you can fire 16 rounds as fast as you can move your finger 16 times on the trigger. But still, that's a lot of shots. And as to Officer Hankinson, If he fired only 10 shots, as the Attorney General claims, or if he fired all 16, as I think probably happened, he's firing blindly through this window. And how long did that continue after there were no further shots from Walker? Because all we know is Walker fired a single shot, and then all the other shots followed that. There could be a point at which this stops being self-defense and starts being prosecutable, but it's difficult because, as I said, this could all happen very, very, very quickly with the weapons involved. But I mean, you could conceive of someone, being charged with a attempted murder or something, some sort of attempted homicide charge, if they continued shooting after a time when there was no threat to them. But that seems to not have been presented to the grand jury. Did you have any thoughts about that, Professor Ahrens?
I mean, again, it's hard for us to even know, and hopefully within the next few days, we'll at least have a better picture of what was presented to the grand jury. In many jurisdictions, you're not permitted to proceed forward with charges if you think that someone's acted in self-defense. There's even a hearing that you have that prevents the grand jury from even considering charges in cases like this. From what I've been able to understand, I don't know that Kentucky actually has that kind of formal process. It doesn't look like it, but it is doctrinally one of those things where if everyone's acting in self-defense, even if everyone is mistaken as to sort of what situation they're facing, it can be hard to charge anyone. The only thing that I thought about really in thinking about sort of doctrinally, whether or not you can bring charges here, is kind of how you time frame this whole situation. I mean, I think it's very difficult if you have police officers who have a warrant, even if it's a problematic warrant, and who are executing it within the terms of the warrant, to start doing things like, and I apologize to everyone here who's in criminal law for saying words like this, imputing malice to them, right? And trying to think about whether or not they're going in there, not caring whether or not people live or die. But absolutely, I think that you can look at the entire course of conduct here, including deciding to make dynamic entry into this home when apparently you thought it was okay for you to knock and wait for someone to answer the door in the first place. I think it starts looking more like police acting recklessly or acting without care for human life. And so again, I don't know, and we don't know exactly what the officers said or what the grand jurors would have heard. But one of the things, and this might, be what I end up talking about a little bit next, one of the things is oftentimes those are things that juries sort out, grand juries maybe in advance, or juries at trial if there are genuine questions about what happened. And I don't know that there's a lot of evidence that that's what happened here.
Yeah, I mean, I think there's no question that the officers were shooting to kill. They had an intent to kill. Right. The only question is whether they were justified in that. The Attorney General of Kentucky has concluded, apparently before he ever walked before the grand jury, that they were justified. And so there was no question that they would be, Cosgrove and Mattingly would be indicted. But you can very much expect that Hankinson's going to present that defense, and it's defense of others. He was firing the shots because his brother officers were being fired at, and under Kentucky law, he does have a right to fire under those circumstances. So anyway, but why don't we move on to your part, because we want to leave enough for everybody to ask questions.
Right, and so that is the last part, right, which is that piece about the grand jury. So I think everyone, whether they're in law school or not, or everyone's familiar with a little jury that sits on a trial, the petite jury, usually 12 people in most jurisdictions. They have to be unanimous. Everything's occurring in open court in terms of witnesses testifying, prosecutors making arguments, defendants there, defense attorneys there. We're all kind of familiar with that process. And probably a lot of you are familiar with the fact that when the jury then goes to deliberate about the charges and try to figure out what to do in a particular case, that process is secret. We don't know what's going on back there. But the actual testimony and argumentation, that's all presided over by a judge. It's all in a record. Everyone can go and watch. And grand jury proceedings are very different, right? This is a process that happens prior, if it exists at all. It's not constitutionally required for states, but if it exists at all, it's pre-trial. Grand juries are similar to regular juries in that they're drawn from the community. They're a little different in that they often sit for more than one case or for a term, maybe a year or a year and a half, hearing a number of cases. But their job is different than the job of the little jury at trial, which is they're not trying to figure out, is this someone who's guilty or not guilty? they're trying to figure out, and there's that standard again, whether or not there's probable cause, whether or not there's enough information here for the prosecutor to proceed forward to trial. Because, certainly one approach would be go to trial, let the jury sort it out, let's not worry about it, they'll figure it out. But the very process of going through trial is humiliating and time consuming and expensive if you're paying for attorneys, can really damage your reputation forever. And so grand juries are kind of a process that's existed for hundreds and hundreds of years. It's not some novel thing that we've come up with, where what the grand jurors are supposed to do is meet in secret, listen to the witnesses privately, and decide, is there enough here for the prosecutor to proceed forward to trial at all, to kind of put someone through that whole process. And some of you know that in some jurisdictions, instead of a grand jury, you actually have an open hearing in front of a judge that returns what's generally called an information, which is the same as a grand jury indictment, a document that allows the prosecutor to proceed forward to trial. But the process is different. The defendant is there, the defense attorney is there, can often ask questions of the witnesses. There's a judge presiding. So it's a very different process than a grand jury proceeding. Kentucky is actually similar to where I practiced in South Carolina, in that basically a prosecutor has to go to the grand jury before going to trial. Sometimes we'll do the information first and then do a grand jury, but doesn't have to, can just proceed directly to a grand jury proceeding. And it's also similar to South Carolina in that generally you don't find out what happened during that grand jury proceeding. Certainly deliberations are always going to be secret, but in many jurisdictions, you get a record of the testimony of the grand jurors, at least if you're the defendant or representing the defendant at trial, so that you can see, hey, if the witnesses come to court, are they testifying consistently with the grand jury testimony that they provided? And it looks like Kentucky may be a jurisdiction where it's not even clear to me that that's available, like the very limited access the defendant or defense attorney may have. As you guys have probably seen in the past 24 hours, the grand jury, we didn't know anything about what happened in front of the grand jury, what charges may or may not have been presented, necessarily who testified or what they testified to. It looks like we're going to find out. The judge who is overseeing Hankinson's case has ordered that the grand jury transcripts be released, and also one of the grand jurors has asked for permission to talk about what happened, because he says the state attorney general is representing that we considered homicide charges and information, and no such thing happened. And here's the thing, prosecutors control the grand jury proceeding. As I said, there's no defense attorney there, there's no defendant there, there's no judge there. Generally, prosecutors decide who to call as witnesses, what questions to ask them, what charges to describe to the grand jurors. In some jurisdictions, they have an ethical obligation to disclose possible defenses. In others, they don't. There's no remedy in the jurisdictions where they don't have that obligation for saying, hey, I shouldn't have been indicted. They didn't disclose my defense to the grand jury. That's not a thing. So really, even if they have an ethical obligation otherwise, prosecutors control the grand jury process pretty much entirely, which is why I think all of those of us who are former defense attorneys, when we look at a prosecutor presenting charges to a grand jury and the grand jury not indicting, we raise eyebrows, right? What went on there? How did that happen? Because ordinarily, there's a reason you have that expression that a grand jury will indict a ham sandwich, because generally they do what the prosecutor tells them to do. And so the revelations from the last 24 hours have been, for many of us, I think, pretty unsurprising, because if the prosecutor isn't presenting homicide charges or information that might support homicide charges to the grand jury, of course the grand jury isn't going to return an indictment. And there weren't what are called no-build documents released here. That's when the grand jury considers a charge and says, nope, there's no probable cause. Instead of indicting or true billing it, they no-bill it. And that doesn't seem to have happened here. So this is actually pretty consistent, I think, with our understanding of how grand juries work, which is they do what prosecutors want them to do. And it's possible that the prosecutor here wanted them to do things that are consistent with substantive criminal law, but it's the prosecutor making that decision, really, not the grand jurors themselves. Yeah. So that, I think, was kind of the end of the background material we wanted to provide to you.
There's one thing. I'm sorry, yeah. There's one thing I wanted just to add. I communicated with someone who's a defense lawyer in Kentucky, and he was telling me that the alternative to a grand jury indictment, and this is far more common, is a preliminary hearing, which is a public hearing, right, where it's a probable cause hearing where witnesses testify, and a judge is there, the defense lawyer is there, the defendant's there, and the judge makes a determination of probable cause. And then if the judge finds probable cause, then the person's held to answer for trial in the trial court. And this guy was telling me that that's very common to do. That's, in fact, most of the time what they do, a preliminary hearing, which everybody can see. Then, this is strange to me, but I think Professor Ahrens has seen this before. In California, that would be it. If you had a preliminary hearing and a person was held to answer, you go to the trial court. In Kentucky, they do a preliminary hearing. If the judge says there's probable cause, then it goes to the grand jury, which just sounds like a rubber stamp on what the judge has done. But what happened in this case is they went right to the grand jury, no public hearing so that we could see it, which preserves this secrecy about what they did. And many times is a very suspicious thing because, why do this in secret? We don't know what the prosecutor asked for. We can make some guesses about it, but now the prosecutor's admitted that he hasn't asked for any charges against the other two officers. And so that's where we're at.
Yeah, and that's exactly the process that existed in South Carolina when I practiced. So it's probably something in that kind of general region of the country that is more common. And it absolutely was the case that when I had a prosecutor who had a case that he or she decided they kind of wanted to pocket veto and not indict, that this was the process that they would use instead of having a preliminary hearing and then going to the grand jury. They would go straight to the grand jury, and that would be the last you'd ever hear of the case, and you wouldn't even know what happened in front of the grand jury. All you would get is a list of the witnesses, and that's it.
Yeah, and it's no coincidence, or it's no mere coincidence, that this is exactly what happened in Ferguson. That the prosecutor went to a grand jury and then said, oh, the grand jury didn't indict. So, no preliminary hearing, which they could have done. So anyway, I think have we gotten through it all then?
I think so. I think that both you and I have ideas probably on what could be done differently.
Yeah.
We have about 20 minutes left, and my guess is that some of our responses to the questions are going to encompass those. So if they don't, maybe I'll give a benediction at the end about what I think could fix this, or at least some of the things I think that could fix this. But why don't we at this point open it up for questions from students and anybody else who may be in the audience and see how that goes.
Okay, let's do it.
Okay, so I've got a bunch of questions that people have sent me as we've been going along. And if you want to ask your question out loud, you can just raise your hand and then I'll call on you. While people are thinking about that, I've got a set of questions that are about grand juries. I'm going to ask them all. Okay, so first, what is the point of a grand jury? Why do we have one? If it's essentially become a vehicle for prosecutors to do whatever they want. Second, what kinds of consequences might there be when prosecutors fail to produce evidence at a grand jury? And then finally, in this case, what do we know, if anything, about the jurors who are part of the grand jury? In particular, do we know anything about their racial demographics?
Okay, well, Professor Ahrens, you want to take a crack at that, or you? The last one first, we don't know anything about their demographics. And as to sanctions for the prosecutor for not presenting evidence, there are none that I'm aware of. But anyway, I'll leave it to Professor Ahrens. You want to take the first part of it?
Yeah, no, the short answer is tradition, right? We've had grand juries since the Magna Carta, so they must be great, right? They must serve some function. But no, for those of you who have taken criminal procedure with me, you know that every time we talk about grand juries and these kinds of public preliminary hearings that Professor Russo and I have talked about, an awful lot of you think you'd really prefer the public out in court hearing where we all get to find out what the witnesses have to say and the defense attorney can ask questions of them. And so I don't know that there is a purpose served by the grand jury proceeding that wouldn't be served by that. In theory, what it is it's the community standing in between the individual and the awesome and terrifying power of the state. But the state's the party in there pulling all the strings. I think that we're duly skeptical about how robust a function the grand jury is really serving.
Yeah, I can add just that in my experience with grand juries, when clients of mine were indicted, and this happened quite a bit, it was generally speaking in gang cases where there were threats against the witnesses and there were concerns that there would be retribution. And so if you could have them called in secret before a grand jury, then nobody knows about them until later when the person's indicted, and then they never really have to come to court until the trial. And so they could keep secret who these people were to try to protect them. So there was some reason to do it in those kinds of cases, but that's, these police cases is a different matter.
Okay, and a related question that I think goes a bit broader, what mechanisms exist to hold prosecutors accountable? So bar associations, democracy, what is there?
Yeah, I mean, democracy is the big one, right? I mean, I think that nobody paid attention. I don't want to say nobody. It's not like literally nobody, but in general, I don't think there was a great deal of attention paid to district attorney elections until the past few years. And now there's a lot more attention, still not the amount of attention that they deserve, because those are the folks who really, particularly in the plea bargaining and sentencing guideline age, those are the folks that are setting policy. They are deciding really what the law is. And so democracy, certainly the most important thing. The Bar Association, absolutely, it's available. And I in no way mean to denigrate our professional regulators. But I think all of you who, like me, when you get your bar magazine every month, turn first to the discipline page to see if anyone you know got disciplined. The amount of discipline that actually occurs is not high. And in criminal cases, my experience has been that bar associations are ever more skeptical about complaints against criminal defense attorneys and prosecutors both, on the theory that, of course, criminal defendants are unhappy about what happened with their cases. So I think that that is a remedy that could be more robust and toothsome than it is. I don't know that right now it is.
Okay, somebody asks what mechanisms are available, if any, to challenge the validity of a warrant. And the question also asks, particularly in this case, where I know there's been a civil action that's been settled. Are there any are there any other vehicles that are open?
Well, let me start off on that one. First, this is something of a moot point now, because Breonna Taylor is dead and there is no charge pending against Kenneth Walker. So in terms of what happens in attacking the sufficiency of a warrant in court, that would happen because someone's being prosecuted and something was seized in connection with the warrant that's being presented against the defendant in court. Then there is a motion called motion to traverse and quash the warrant. Traverse means to go through the affidavit, excise out things that are false, not supported by the evidence. Then once you do that, you look at the warrant again to see if it's sufficient. My, recitation of what was in the warrant, I was saying to Professor Ahrens before, it looked very thin to me. In other words, if I was defending Mr. Walker and there was something taken from that apartment that was going to be presented in evidence against him, I would definitely make a motion to traverse that warrant, because the information was stale. It was 2 months before, a lot of it. It was very amorphous in terms of, oh, he received mail there, not when, not why. It just didn't seem to me to be a strong warrant. So I would have made that motion, and I would have, in the course of that motion, you would excise out the false information about the United States Postal Service saying that a package was suspicious, when the Postal Service is saying we never said that. So once you excise that out, what's left? And if what turns out is the result, there's no probable cause to support the warrant, then you would be able to exclude any evidence that was seized as a result of the warrant, and then there'd be no case left. The problem here is none of those issues exist right now. No one's being prosecuted for the crime, and nothing was seized as a result of the warrant. As a matter of fact, the police executed a second warrant at 3:30 in the morning, and no money and no drugs and no weapons and no nothing was found. So there's nothing there. And Professor Ahrens, do you have anything more?
Oh, you're muted.
There we go. I'm unmuting. Sorry. No, and a couple of other things, right? Let's assume that they'd found anything. Unless Breonna Taylor herself had lived and was being charged, her ex-boyfriend, who doesn't live in her apartment, probably doesn't even have standing to do anything that Professor Russo just described. He may not have any sort of standing or expectation of privacy in the apartment of his ex-girlfriend. He might. I mean, maybe if you really do receive packages at somebody else's apartment and regularly visit there, maybe you could establish something, but usually it's very hard to establish that expectation of privacy in a place where you don't live and you aren't currently. So even with all of that, I'm not sure there would be much to do. And the exclusionary rule is the main way that we protect Fourth Amendment rights. Now, the other kinds of ways we do, right, there are state tort suits, and that's what has been settled in this case. Breonna Taylor's family has settled a wrongful death suit with the city of Louisville for $12 million. There are also federal civil rights actions. So the federal government right now is supposed to be investigating what happened in this case. And if there were a constitutional violation, including a violation of her Fourth Amendment rights, then you could bring a federal civil rights 1983 action against the police officers, the department, et cetera. There are all sorts of immunity doctrines that I think in the interest of time, I will not bore you with, but that would be a possibility in this case if it turns out that there's a constitutional violation, as opposed to just kind of my speculation and Professor Russo's speculation about there being a constitutional violation.
And if you want to talk about just, you know, recklessness, I mean, it plays into my sense of whether or not the police acted recklessly, that this was such a thin warrant, and especially the way it was executed was just, I don't understand it at all, frankly. Nighttime, no knock, all of that.
We've got two questions about the indictment. Somebody asked, what is wanton endangerment? And somebody else asks about their understanding of the indictment, specifically that the wanton endangerment charges related to shooting into the neighbor's house, nothing to do with Breonna Taylor herself. And they ask whether that would be because of the self-defense argument.
So I read wanton endangerment. I'll just do it one more time. This is the Kentucky law, okay? A person is guilty of wanton endangerment in the first degree when, under circumstances manifesting extreme indifference to the value of human life, he wantonly engages in conduct which creates a substantial danger of death or serious physical injury to another person. It's acting extremely recklessly, you know, disregarding the value of human life and firing these shots. Now, apparently, the evidence is that none of the shots fired by Officer Hankinson struck Breonna Taylor. All his shots, as far as we know right now, went into walls and went into other apartments and, you know, sailed through other people's places. But he can't be charged with a criminal homicide because he didn't, apparently the evidence says he didn't kill anybody. His shots didn't kill anybody. But he can be charged as a result of firing those shots in some sort of reckless or wanton manner. And so that's what his charge is. I forgot the other question, but Professor Ahrens, did you have more on that?
And the last question that people have sent is kind of a law reform question. So, you know, if a legislature wanted to prevent something like this from happening in the future, either in the first place or to allow there to be, you know, criminal charges against police officers who engaged in this kind of behavior, you know, what kinds of reforms should they think about?
I mean, they're the kind of, because I was thinking about this, obviously, they're the kind of micro reforms that, you know, are kind of addressing specifically some of the things that happened here. So in the wake of this, I think some of you have seen the state legislator who actually introduced the legislation has now been arrested in protest. But legislation in Kentucky and other jurisdictions to either restrict the use of or eliminate entirely the use of no-knock warrants. That we recognize the kinds of dangers that they pose, and the Supreme Court has told us about the dangers we all know. And so maybe either to eliminate their use entirely or to restrict their use either to SWAT teams that might be trained to use them, or to cases where you make much more of a showing than I think anyone would argue is made here, that you really would require a no-knock warrant. So that's one thing. There are also, and again, I'm always kind of skeptical of these sorts of reforms, technological problems here, like the fact that apparently these were officers who had body cameras but didn't have them turned on, which contributes to our inability to know exactly what happened. And so technological solutions like requiring officers to have body cameras and to have them on whenever they are responding to events or executing a warrant. So those are kind of, I think, you know, more granular solutions. I mean, if we're thinking about how you want to prevent things like this from happening at all, one of the things you want to think about is what is it that the police are out there doing? They're out there executing these warrants with all of this artillery in a kind of militaristic fashion, in large part, one, because we've given them the equipment to do it, and two, because we've told them they're at war with drugs, right? That this is an important thing that needs a strong, robust criminal law response, and where police officers are going to be in constant danger, as all of us are, from the very existence of the illicit drug trade. And so an awful lot of the things that I think we see police do are in response to substantive criminal law that we are asking them to enforce. So absolutely, we can and should ask police to enforce it differently. But I really think we want to think about the underlying substantive criminal law, particularly when it's the kind of law that I always say doesn't have victims who come forward and self-identify. If police are investigating a rape or a homicide, they have people who are identifiable who come forth and say, this is what happened. Drugs don't do that. If you want to find them, you have to go in places and you have to snoop on people and you have to surveil them. And so I think we really need to be having a serious conversation about whether or not that kind of surveillance and action is worth this.
Yeah. I'm just really bothered every time I hear people refer to this as a tragedy. I think that dishonors Breonna Taylor's memory and what happened here. What was to be gained by serving this warrant at night and the knocking down that door? What was to be gained was maybe they'd find some drugs, maybe they'd find some money. What was to be lost? An innocent life, and perhaps more. I mean, her sister did live there. An infant very frequently lived there. That was in an apartment building into which at least 32 and perhaps 38 shots were fired and that went through walls. That's what happened. Other people could have been killed. Is this really worth it? To me, I think that there should be a more stringent standard imposed on the police officers because it's their choice whether to serve this warrant at night. It's their choice whether to seek a no-knock warrant. And they should, if they're going to start blazing away with the guns, they should justify that it was necessary in the first instance for them to create a situation in which that was a real possibility because the person inside the apartment doesn't know what's going to happen. They all they hear is pounding on their door, and maybe they don't hear police. But it seems to me that the idea that officers can be reckless in the execution of a warrant and create a situation in which someone's killed should somehow be a prosecutable thing. And it is just, to me, it's just appalling to continually say in these situations, oh, well, this was just a tragedy. No, it's worse than that. It's worse than that. And there were so many choices to do this differently. There's no way this should have been a no-knock warrant. There's no way it should have been served at night. There was no point of that. They didn't suspect that Breonna Taylor was even a criminal, and they had a very vague suspicion that maybe they'd find something they could use in her home. So.
Okay, and we've got two last questions. I'll ask them both because we've only got 3 minutes left here. Okay, one is, the first one is this, Louisville, Kentucky has a racial makeup that is about 70% white. Should we see what happened here, or should we see the laws that enabled the scenario to unfold the way it did as reflecting white supremacy or the interests of the white majority? And then secondarily, could there be federal intervention in this scenario, and should we expect there to be?
I mean, I think it's probably easier to answer the second part, which is I wouldn't, at least right now, expect that sort of intervention. Certainly, the current administration has expressed that we should be regulating police less, that we need to let police have more discretion, that we need less federal oversight, and that perhaps we should be vacating the existing consent decrees that cities like Seattle have right now to try to respond to police officers using force in unconstitutional ways. So I wouldn't expect the current administration to be doing much about these sorts of situations, other than perhaps when there are protests throwing gasoline on the fire. On the other hand, if you are trying to think about, the kinds of things that maybe we can do going forward about these kinds of situations and whether or not these situations reflect white supremacy. I mean, I'm thinking about what Professor Russo just said, and I don't think that there's any way for you to think about police officers making the decision to use this kind of force under those kinds of circumstances for this sort of offense without thinking you can only do that if you discount the lives that you're endangering, right? If you don't fully see the people whose lives you're risking as the kind of people you are. And so I think it's impossible not to see the racial dimension to cases like this, because I don't see how you behave that way unless, and you can do this even if you yourself are a person of color, right? Unless you somehow discount the lives of the people whose homes you're invading.
Black lives can't possibly matter if you're firing 38 shots into an apartment building where there's human beings living there, all of whom are African Americans. You know, that they knew that, but you know, do white defendants in white collar cases get subject to no-knock 12 a.m. warrants? No. So this is, of course, it's about white privilege. You know, it's got to stop. I mean, it's got to stop.
Okay, and with that, I think I have to draw this to a close. Thank you both so much for this, for sharing your time and your expertise with all of us today. I am sure I can volunteer you both to answer follow-up questions if members of the audience have them. Thanks again.
Thank you.
Thank you, Charlotte, for organizing. So,
oh, all credit to Professor Coleman.
Thank you, Professor Coleman and Claudine Denmark.